Good afternoon, everyone, and thank you for joining me today. If you have any questions during my presentation, please add them to the chat. I will be talking to you today about a recent Ontario case called Calmusky and Calmusky. Before I get to the Calmusky decision, as you can see, the title of my presentation is RIF Designations Now Subject to Pecore? So as a refresh, what is the Pecore case for those of you who do not know or who may not recall? The Pecore and Pecore decision and Madsen Estate and Saylor decision are those of the Supreme Court of Canada in 2007. Those decisions held that the presumption of resulting trust applies where there is a gratuitous transfer of assets from a parent to a non-dependent adult child. In those cases, the law presumes that the adult child holds the assets in trust for the parent unless the adult child can establish that the assets were intended to be a gift at the time of the transfer. So now we have our background to the Calmusky decision. We know about the presumption of resulting trust from Pecore, and those of you might now think, oh, I do remember this case. It's often applied to joint bank accounts between a parent and their non-dependent adult child. So I'll get into the facts of Calmusky. Henry Calmusky, who I will refer to as Dad so that we don't get the names mixed up, died at the age of 94. He was predeceased by his wife, Mary, and one of his sons. He was survived by two adult children, Gary and Randy. 2 days after Mary died, Dad changed his will. He designated Randy and Gary as his executors of his estate, but they did not become beneficiaries under his last will and testament. Shortly thereafter, Dad added Gary to two of his bank accounts and designated Gary as beneficiary of his RIF. Dad's assets at the time of his death included three joint bank accounts, one of approximately $30,000 with BMO, another savings account with TD Bank of approximately $250,000, and a checking account with TD Bank for approximately $4,600. Dad also had a RIF with TD, an approximate amount of $40,000. He owned a house, and he was the only owner of that house, and he owned a vehicle. Gary's position was that he became the sole beneficial owner of the joint bank accounts after Dad died. That was because those joint bank accounts had the right of survivorship. Gary also claimed that he was the sole beneficiary of the RIF funds as the designated beneficiary of the RIF. Randy's position, in contrast, was that the presumption of resulting trust applied to the joint bank accounts. For us, that's not novel. But Randy also argued that the presumption of resulting trust, as we know from Pecore, applies to the RIF. And that argument was a bit novel. If it wasn't novel in terms of argument in court, it was certainly novel in terms of the decision that flowed from that argument. Gary alleged that Dad intended to benefit him to the exclusion of Randy because years prior, Gary and his mom had invested in Randy's business. Randy's business failed, and Gary and his mom lost money that was never recouped. Apparently, Dad was troubled by Gary's loss, and by gifting the joint accounts and the RIF to Gary, Dad was equalizing the money which had been given to Randy for his business. These are obviously Randy's arguments. In addition, Randy and Gary had creditors as a result of Randy's failed business, and these creditors would claim against any gifts to Randy and Gary through the will. On this basis, Gary argued that the two residuary beneficiaries named in the will, who was actually a nephew of Dad and a grandson of Dad, were merely placeholders for Randy and Gary. In other words, Randy was a beneficiary and Gary was a beneficiary, but Gary benefited more. Randy's arguments. He acknowledged his failed business venture and the loss of money by his mom and his brother Gary. He also acknowledged a conversation between him and his dad, during which Randy suggested that someone else be a beneficiary of the will because of Randy's creditors. Randy even suggested his son Kyle, who did become the named beneficiary in the will. Despite all of the above, Randy still disagreed with Gary's placeholder argument and theory. He alleged that the nephew and the grandson were true residuary beneficiaries of Dad's will. Now we get into a bit of the evidence. The timeline. As we talked about, there were significant financial losses and investment in Randy's company. Claims were made by Gary and his mom to the trustee in bankruptcy. Those claims were made in 2013. In March of 2014, Gary and mom were advised that their claims were disallowed, and they were even ordered to repay interest on their investments. Between March and August 2014, apparently mom and dad were quite troubled by the financial losses. On August 4th, 2014, mom passes away. 2 days later, on August 6, 2014, Dad goes to his lawyer's office to make a new will. The will is also signed that day. The evidence of Dad's nephew is that he agreed with Gary's placeholder theory. He said, yes, I'm a placeholder, I'm not a true beneficiary of the will. He even assigned his interest in Dad's estate to Gary. We also learn about the contemporaneous evidence at the time of jointing the accounts from the bank, but we're going to come back to this as a separate piece because of how it relates to the RIF. Randy's evidence is that Gary did not contribute to the joint accounts and did not have access to them while Dad was alive. This suggested that Dad did not intend that Gary benefit from the accounts. The drafting solicitor did not ask about Dad's assets, drafting solicitor of the will, did not ask about Dad's assets, his bank accounts, or his RIF. So unfortunately, the lawyer's notes were silent on those points. There was no indication in the will or on the face of the will that the nephew and the grandson were holding their residuary interest for somebody else. Randy asserted that Kyle, who was his son, was a true beneficiary, and Kyle agreed with his dad. Randy has a discussion with his dad on August 8th, 2014. So now we're 2 days after making the new will, only 4 days after his mother has passed away. Randy's evidence is that his dad showed him statements from the bank accounts with BMO and TD, but there was no discussion of jointing those accounts. August 11th, 2014. Now we are 5 days after Dad signed his new will. He visits his branch with BMO, and Gary joins him. They met with the assistant bank manager for approximately 1 hour. The assistant bank manager is familiar with Dad from previous visits, remembers the visit during the trial and the hearing. Instructions are given by Dad to open a new checking account that is to be joint with Gary. And this was to replace the joint checking account that Dad had with Mom. So the husband and wife had joint bank accounts. Wife passes away, and now Dad is opening a new bank account and adding his one son as a joint account holder. Dad and Gary both sign an account opening slip which indicates joint with right of survivorship. The next day, they return to BMO to open a new joint savings account. On August 20th, 2014, more than 1 week after attending TD, Dad attends his BMO branch. Again, Gary joins him. This time, the meeting is with the branch's manager of financial services for about a half an hour to 1 hour. The manager was a new employee and did not recall meeting Dad before. The evidence that that manager gives later on is more about what she would have said to somebody in Dad's position, not what she actually recalled. Dad gave instructions to add Gary to the BMO account in place of his wife, and on the account opening slip alongside the word survivorship, the box marked yes was checked off. At the same meeting, Dad signed a designation of beneficiary for his RIF, naming Gary 100% beneficiary. So up until this point in the case, we've got evidence about the joint bank accounts, how they come to be jointed between Dad and his son Gary, the circumstances leading to the jointing, and the documentation that has been signed with the bank to joint those accounts. The bank documents in support of his position, Gary points to the bank documents that Dad signed relating to the joint accounts, which indicate right of survivorship. Gary also points to the testimony of the bank employees who met with Dad and explained the bank documents to him, including what would happen to the funds upon Dad's death. In contrast, Randy asserted that the banking documents merely established the legal rights between the bank and the account holder. They do not, by their terms, establish beneficial ownership of the funds as between the two bank owners or two joint account holders. Randy also asserts that the evidence of the bank employees is inconclusive and does not establish Gary's beneficial ownership of the jointly held funds upon Dad's death. So, getting back to Pecore in terms of our refresh and our recall, we know from Pecore that there was a lot of discussion about the bank documents. We also know from Pecore that the Supreme Court of Canada held that the bank documentation setting up a joint account may be detailed enough to provide strong evidence of the transferor's intention that the transferee became the beneficial owner of the funds. So we know that it's possible that the bank documentations can be strong evidence, but not that it's always strong evidence. Turning to, more specifically, the evidence of those bank employees. The trial judge was satisfied that the explanations given, or what would have been given by the bank employees, were sufficient to ensure that Dad understood that Gary would receive the joint accounts upon Dad's death. However, the evidence of the bank employees, together with the contents of the bank documents, were not sufficient to support the conclusion that Dad intended Gary to become the owner of those funds or to be the beneficial owner of those funds. The difference being that Dad understood Gary would receive the funds on death and then perhaps have to do something with them, versus that he would own those funds on death and become the owner. The conclusion about the joint bank accounts is that Gary did not rebut the presumption of resulting trust, and the jointly held funds form part of Dad's estate. As we know from the beginning of the presentation, the slides, those amounts were quite substantial. So the trial judge took some time to go through the analysis of the joint bank accounts, and it matters to us because we then turn to the RIF. As we know, Randy argued that the presumption of resulting trust applied to the RIF. The analysis of the RIF is that, again, Pecore applies, as it did for the joint bank accounts. Randy, interestingly, relies on case law, which predates Pecore, some of which is from even another province. The court held that the principles in Pecore apply more generally to other gratuitous transfers of property interests. The same evidentiary challenge arises from a joint bank account and a RIF designation. So we see the trial judge grappling with this idea that this presumption would apply to joint bank accounts, but not to a RIF that was quite substantial. The court finds that when we consider the evidentiary challenges that have to apply in a situation of a joint bank account, those are actually present in the case of a RIF designation as well. As the judge held, the difficulty in determining the deceased transfer's intention, in this case it was the dad, at the time he transferred legal as opposed to beneficial entitlement to the funds, and whether the transfer is effective immediately, which it is with the joint accounts, or on the transferor's death, the RIF. The evidentiary burden in both situations should be on the transferee, in this case, Gary. So we see that the trial judge analogizes between the joint accounts and the RIF. However, how is a RIF different? Unlike the jointing of a bank account, a RIF designation can be, or often is, done unilaterally by the transferor. The future transferee might not have any knowledge of the designation until long after it is made, or even after the transferor's death. So this idea that the transferee, in this case Gary, would have knowledge, or should always or often have knowledge, contemporaneous evidence of the transfer at the time that it occurred, is not necessarily the case for a RIF designation as it would be for the jointing of a bank account. With a joint bank account, Gary goes into the bank with dad, signs documents as well, is there to also acknowledge and accept that he became a joint account holder, but not so for a RIF. A RIF is also different from joint bank accounts because a RIF designation takes effect upon death. The designation, or the designated beneficiary and the transferee, does not have legal or beneficial ownership of the RIF until after the transferor's death. Unlike the jointing of a bank account, which can change legal and or beneficial ownership at the time of jointing. In terms of what else we know with RIFs and how they are different, the Succession Law Reform Act acknowledges, it's a statute in Ontario that acknowledges that beneficiary designations are a common estate planning tool. The SLRA provides that designations under certain plans, including a retirement savings plan and a retirement income fund, can be made either through the plan administrator or through a designation in a will. So we know that someone's estate planning can be done with, in terms of a RIF, can be done either with the bank or the plan administrator or through their will. We also know that a later designation revokes an earlier designation, whether that designation is through the plan administrator or through the will. The effect of Calmusky, it has raised some concerns among particularly estate practitioners in Ontario. It's raised some concerns among those in working in the financial sector and financial institutions. We know that Calmusky is currently persuasive authority in Ontario, and that now we can argue that RIF designations are subject to the presumption of resulting trust. That needs to then be rebutted by the person who's been designated as the beneficiary. It remains to be seen if we will have a subsequent decision which holds the opposite of Calmusky, and then we'll have competing authority at the same level of court. For now, we do not. Calmusky was released on March 16th, 2020, right amidst the time of the beginning of the COVID shutdown. So what do we do now? For financial institutions, do they pay the designated funds of a RIF to the beneficiary? Essentially, I would say maybe yes, and that reliance could be placed upon the bank documentation as the contract between the bank and the transferor as to who will receive the funds. So essentially, the bank can rely on the comments in this case and in other cases that is essentially a document and an agreement between the bank and the transferor as to where the funds will go, who will receive those funds, but it's not necessarily determinative of beneficial ownership. For estate lawyers, a discussion about the Calmusky decision and should the transferor designate an independent adult child as the beneficiary is likely prudent with your client. Perhaps it's even safer, in some cases more prudent, to make the designation through the will. If that is done, the drafting solicitor can include language about the testator's intention to make a gift to that designated beneficiary. It can be explicit. The will can become evidence of the gift in a way that the banking documentation may not become evidence of the gift. Possible risks need to be identified to the client, of course, in terms of the designations, and if one should come later, especially with the plan administrator in the future, it would revoke the designation in the will. For clients, there may very well be good reason why a client would prefer to make the designation through the plan administrator and not through the will. One of the most common reasons is because they don't want those who read the will to know about that designation and for that individual to receive that benefit. Where there is a preference to designate through the plan administrator, the bank documentation may not be enough for the future beneficiary to rebut the presumption of resulting trust. So perhaps something more is needed, and it might be prudent to have something more. What would that be? It remains to be seen, but perhaps some note, some letter, something from the transferor in addition to the bank documentation that says, yes, this is a gift, yes, I want the designated beneficiary to receive this gift, and hopefully that will assist the designated beneficiary in rebutting the presumption of resulting trust, should it still apply. So in ending, if you have any questions, please join me for my Q&A session, which is next at 2:30. And thank you again for joining me, and stay tuned for the Calmusky decision and what might happen in the future with this decision. First, please head to the main stage for some remarks from our conference hosts. Thank you.